Welcome to Florida Newsmakers. I'm Trimmel Gomes. Come November, voters will get to decide the fate of Amendment 2, which will allow marijuana to be used in certain medical conditions. Florida could be the first southern state to adopt medical marijuana thanks to the Yes on 2 campaign, but there is intense opposition from the No on 2 side, which is working to ensure the effort fails to get the required 60% plus voter approval. Here to make the case for both are attorneys Reggie Garcia, who's working with United for Care and representing the Yes on 2 campaign, and is Susan Kelsey, who's on the opposing side with No on 2. Welcome to the program.
Thank you.
All right, now we're going to keep this discussion free-flowing, but keeping it with respect to time. We're going to try and keep responses short, so let's go ahead and get right to it. Ms. Kelsey, we've been watching the campaign for medical marijuana unfold. What should people know about Amendment 2?
First, people should understand that it's going in the Constitution. It is not a statute. It's not a regulation. It's very difficult to change something that's in the Constitution. It requires another constitutional amendment, which is very difficult to do. So that's something they need to keep in mind, is that this cannot be changed, it cannot be limited or restricted by laws later. Second, this is not limited to the 74-word ballot summary, which is the only thing they'll see when they go to vote. This amendment is actually 1,196 words long. It's 2 full pages, single-spaced. So I would just encourage people to go and read the full text of the amendment before they vote.
Mr. Garcia, why should people support Amendment 2?
Well, thank you for having us. And again, that is an important point because there are 3 amendments this time on the constitutional amendments, and this one is 2. And Florida passed an amendment several years ago that said future ones have to pass by 60% or a supermajority. So this is about, from our perspective, death with dignity and compassion. Ms. Kelsey is right. You'll see a 74-word ballot summary, but the actual constitutional amendment is 2 pages, and I think that's a good thing. As well, I encourage people to read it. It's got 10 very specific definitions, including what constitutes, quote-unquote, a debilitating medical condition, which are the 9 very chronic, debilitating illnesses that will qualify for medical marijuana.
All right. So you touched on this, the constraint with that 74-word summary. What is wrong with the way it's written?
What's wrong with the way it's written is that there's so much that it doesn't tell you. And I've done 18 constitutional amendment cases, so I'm familiar with how hard it is to write. 75 words is the limit. This is one under the limit. It's hard to get everything important in there. But in this case, there is so much left out, and there's so much that people will not understand just from the summary, so they really do need to read the text of the amendment.
What is left out?
There are important things like the fact that there is no, it says debilitating conditions, but there is no objective definition of a debilitating condition. There is no uniformity. There is immunity granted to the doctors, to the patients, to the caregivers, to the growers, and to the processors. That's not mentioned in here anywhere. There's also a misleading reference to federal law, because it says it doesn't require a violation of federal law, but of course it still is illegal under federal law. People may not understand after reading the short summary that this is not talking about a special kind of marijuana, medical marijuana as a phrase. Some people are confused about what that is and may not understand that this is not a special kind of marijuana, it's just smoking pot. So those are among some of the things that are not covered in the ballot summary, and you have to read the text to get that.
Mr. Garcia, should Amendment 2 pass, will the legislature be able to go back and fix some of the problems Ms. Kelsey and others are concerned about?
Well, I wouldn't call them problems, and I guess I would respectfully disagree. Debilitating medical condition, it's right there defined as cancer, glaucoma, HIV, hepatitis, ALS, Crohn's disease, Parkinson's disease, MLS, or other conditions. The legislature will do an implementing bill. The Department of Health will do implementing administrative rules. Both of those will be very public proceedings. I don't think the legislature, if this passes, can change what some of the definitions are, but if there's some ambiguities, they can do some implementing legislation as health can through rules to clarify some of those issues. I would say that the reason it's on the ballot to begin with is almost 800,000 Floridians and voters put it on the ballot, and the Supreme Court, again, not speaking of the merits, but at least did a facial review to say that the ballot summary, the 74 words voters will see, didn't involve more than one subject and was not misleading. So this is really the third step in the process, and I think speaks to the overwhelming support for this.
Or other conditions. I already know that you have issues with that being so broad.
Right, right. It is open-ended, and the Supreme Court in the advisory opinion proceeding that we just went through, the Supreme Court is not allowed to rule on the merits. They can't rule on what it's going to mean in the actual practice. So what they said was it's not open-ended because the doctor still has to determine that it's a debilitating condition. But the doctor has to determine it's a debilitating condition. The definition of debilitating medical condition says, or other conditions that a doctor believes warrant use of the medical marijuana. So it's completely circular. There is no objective definition and no uniformity. So all three of us, if we were doctors, might have a different idea about what is debilitating. So if I'm the most lenient doctor and I'll give it for anything, people are going to flock to me. You know, the word's going to get out that I'll give it for anything. And then, bingo, we've got the pill mill again. So that's a tremendous problem, and the legislature cannot change, restrict, limit, or contradict the words in the Constitution. So it gets back to the fact that this is in the Constitution is tremendously important.
We're already seeing legal challenges over the rules for those allowed to sell medical marijuana for Charlotte's Web. Should we just brace for challenges if Amendment 2 passes, Mr. Garcia?
Well, first of all, and that's a good point, and this is frankly very confusing to most voters and citizens. Charlotte's Web was done by the Florida legislature this spring as a statute, and right now the Department of Health is implementing administrative rules, and they're getting lots of opinions about that, but that is very, very limited in scope. This, while it will have an implementing bill by the legislature and separate rulemaking, here we have the benefit of, I believe, 10 very tight definitions, including the fact that a Florida physician whose license is on the line has to quote-unquote certify that someone has one of these 9 debilitating conditions or debilitating medical conditions or one of the other conditions, which I think gives them some latitude for new diseases, PTSD, chronic illnesses. Is there room for abuse if you have a dishonest physician? Sure. Do we already have that under current law? Yes, we do. So again, we think this outweighs any risks or ambiguities.
All right, as we wrap up, I'll give both of you a chance to make your final pitch to voters, on at least on this program. Ms. Kelsey.
Thank you. I would just encourage again, everyone, please read this. It's 1,196 words. It's going in the Constitution where it can't be changed without another constitutional amendment. It has no age limit. It doesn't limit where the pot shops can go. There's no objective or uniform definition for what conditions it can be given for or recommended for. It does not require prescription. It violates federal law. And that's not even all of the problems. So I would just encourage people to read the amendment, and of course they can go to the campaign website, which is VoteNo2, votekno2.org, and get a full supply of information and media reports about it.
Mr. Garcia.
Thank you, and this program and others is very helpful. We appreciate the opportunity. This is a good thing. It's one more tool to give a physician. I respectfully disagree. It's called a certification instead of a prescription, but it's functionally the same thing. I think the definitions are very tight. There's 9 medical debilitating conditions that specifically are addressed, not in the summary, but in the ballot summary. So it's one other tool for physicians, and it's one other option, not exclusive of traditional prescription medications, for families that are suffering, particularly people to die with dignity and other people just to have a compassionate option.
Well, thank you both for joining us, and we'll get to see how the voters decide on this issue come November. And to our viewers, we'll catch you next time.